so much. We're going to get started. Before we get started, if you haven't already, there's a sign-in sheet up here that Ted's doing right now, and information packets. I think there's a couple left, or maybe just one. Oh, okay, good. Oh, you need that. Okay, well then you'll have to share with a friend at the moment, and we can get you more if you need them. There's also pens up here and mints. So before I turn it over to Tom for just a minute, he's going to say a few opening remarks. I just wanted to, again, thank you for coming, and to let you know that in addition to this board training that we're going to do for you all tonight, the town council does intend to have each board in, just come to a town council meeting, maybe a couple boards, per meeting, just to get an update per the charter of what you all have been up to. To tell us about any significant actions that have been taken by your committee, projects under discussion, anticipated activity for the coming year. It's more just of a listening session for the council, so just so they kind of are apprised of what's been going on with your board. So with that, I'll turn it over to Chairman Dolan, and we'll get started.
Well, thank you all for coming tonight. I know you're all volunteers giving to the community, and sometimes these meetings you say, oh, another meeting. But this is something that the council believes is going to be worthwhile. Especially with our help from the NHMA here, we're going to be looking at what are the requirements, even though as volunteers say, well, I'm just giving my time, but we do have some legal requirements of how we need to run a meeting, some of the nuances of public versus non-public meetings versus something called a non-meeting, which some of you may be familiar with, which is a meeting that isn't covered by the state statute 91A. So you're gonna either learn about that or get refreshed on that. So you have your notebooks there. Please take notes. The other thing that we're going to talk about is how to effectively run a meeting. We have been encouraging all our boards and commissions, and when it makes sense, to try to openly engage with the public from time to time using elements of public comment. There's really two kinds of public comment that you'll learn about in the meeting process. One is the hearings. You have meetings, sometimes the hearings, where you have to take input from the public. Another time is during just a generic meeting, is as chairman or vice chairman, if you're presiding over a meeting, it may make sense to take public input, just generic public input. And if you've watched or been to a town council meeting, you know that we do that usually at the beginning of the meeting. We usually try to target about 15 minutes. That can be very intimidating for a chairman or a vice chairman, whoever's running the meeting, and say, oh man, public comment, what if they're upset with us, or how do I get control of that? Or how do I limit that so that I don't have 3 hours of public comment and we never get to our business? So there are some tricks of the trade, if you will, about how to manage the public comment, how to interact so that you don't inflame an argument, let the people speak. And you also can limit the time. Some of the tricks of the trade are, as if you had intended as the chairman of the meeting to spend 15 minutes on public comment, and you've gone through your 15 minutes, you can announce, all right, I'm going to take one more comment, or I'm going to take two more comments. That's a technique. And so you're going to get lots of hints. Please use this meeting as an interactive process. Ask questions. We'll be here to answer questions, those of us who have done this for a while especially. And again, thank you so much for devoting some of your personal time to this. It is important. And for those who couldn't make it, we are videotaping this so they can catch up with a viewing of the videotape. Thanks, Lisa.
Thanks, Tom. I want to introduce you to who's going to be doing our training tonight. This is Attorney Stephen Buckley from the New Hampshire Municipal Association. He actually directs their legal services program with responsibility for providing legal advice to members like us and overseeing the training programs and educational publications for municipal officials. He practiced law from 1984 to 2014 with the firm Hage Hodis, concentrating in representing municipalities. In his hometown of Bow, Steve was a member of the planning board for 12 years, so he's got some experience with this, and served as a member of the budget committee as well. He's a past chairman and current member of the executive committee of the Central New Hampshire Regional Planning Commission. He received his BA from San Diego State University and his JD from the University of New Hampshire School of Law. And I'm very grateful to him for being here tonight. So thanks so much.
No Aztecs. I'm very privileged to have this job with the New Hampshire Municipal Association. I've had it since 2014. And we thank Londonderry for being a member, because it's with all of the cities and towns that are members that allows us to support NHMA, support staff to do these programs for our members, to give them tools that you can use in order to do your job as a local elected or appointed official. Let me start out by saying a couple of things about the importance of a well-run meeting. And certainly we're going to talk about the right to know law too, but part of what we're going to talk about, a good part, is how to do a well-run meeting. And the starting point is the understanding, I think, as the chair of the council is referring to, your volunteers. And realistically, you have a scarce resource, volunteer time. If volunteers get tired, or they feel like their time is being wasted, or it's not being used effectively, you're going to lose those volunteers. And as far as I'm concerned, one of the most precious resources New Hampshire municipalities have is those volunteers who spend their time at those meetings till the wee hours of the morning doing the business of the planning board, ZBA, zoning board of adjustment, conservation commission, et cetera. That's an essential ingredient to local government. It is what keeps local government running. We could not run New Hampshire government without volunteers. And so recognizing those volunteers are very important. Their time is a precious resource, because their time is being gobbled up by many other demands on their time. And so you want to make sure that their meetings are effective, they feel like they're getting done, and they're not wasting their time. Because if the volunteers feel like they're wasting their time, or things are not getting done, they're going to resign or not come and not be as effective participants. The other thing I want to say, and I know you might take this to heart in terms of a form of criticism, but it's a thing that I have observed over the years with regards to how meetings run effectively. And a big part of that is making sure you have an effective organization of the room so that the participants are brought into the process. Now, this room is pretty good because you have the materials being projected up front so everyone can see. Your council can all see the materials because they have screens that are being projected in front of them, whatever board members are there. But one of the things I would suggest in a situation with a room like this, I would reorient all of the chairs so that they are diagonal to that part of the room coming this way. And all the audience is pointing this direction. I would have the speaker who's presenting to the council pointing this way. So you have two converging lines. The audience is going to be viewing this direction, the presenter is going to be viewing this direction, and I would put the screen over here so that you would have what I usually see in rooms designed like that, collective focus on what's going on in front of the room. The audience is looking this way, the presenter is looking this way, and the board is here. And I think that draws people into the process. So, and I can't tell you how many times I've been to towns where you've got the audience back here, and then the planning board is sitting behind a rectangle table right here. And they're all, and they circumnavigate the entire table. And it's as if they're talking to each other. And the audience is back there, and they're mumbling to each other, and the audience oftentimes can't hear what's going on. And that's just the worst type of meeting organization of a room. It destroys the sense of participation of the members who are coming to your meeting for the first time. And that's the other thing you always have to keep in mind when you're having a public meeting. You're going to be having people for the very first and maybe the only time in their life they've come to a meeting at Town Hall. And that's because typically in the land use area, they've gotten a notice. They're in a butter to a project. Could be a site plan, could be a subdivision, could be a variance application. And they've gotten a notice something's going to happen to land near them. And they come to Town Hall for the first and only time in their life to participate in government. And as a consequence, I'm not speaking close enough.
I was just going to try and move it closer to you, just
Yeah,
so.
I'm going to
set
move
up on
around a
the
lot,
video.
so
Yeah.
I'm going to apologize to the video person back there. Sorry about that. So they're going to come to your meeting for the first time, and their first impression of what government's about is going to be that first meeting they come to. So understand that's part of your, if you have that point of view, when you're thinking about there are people in the room for the first time that have come to a public meeting, you understand that your way in which you project yourselves is indicative of what you are saying about government in your particular town, in the town of Londonderry, as the case may be here. So that's the other thing I think it's important to keep in mind. Make sure the audience is comfortable. Make sure they have a way to visually be part of the process. Understand that maybe they're for the first time, so you really have to be attentive to their needs, and then do the other things which are appropriate to make sure their participation is going to be effective. Make sure your rules of procedure are right up front at the door as they come in. They can grab a copy of them and the agenda. And very important, start on time. And don't waste their time either. Try to move the agenda in an effective way. Those are the really key elements, as far as I'm concerned, of making sure your meeting is going to run in a fashion that is going to get the job done for your particular jurisdiction or the board's requirements for activities for that particular meeting that night. So this presentation is part right to know law and part how to do an effective meeting. So I always start with the right to know law's origin, which is the New Hampshire Constitution. Just as a way of background, the whole process by which government became more open was really a product of the 1960s. So during the 1960s, sunshine laws became very common, starting with the Federal Freedom of Information Act and then other states adopting sunshine laws. So sunshine laws would be everything from open records to open meetings. And in fact, our right to know law presentation is really broken down into those two parts, public records and open meetings. So emerging from the 1960s were statutes like New Hampshire's, which is designed under Section 91A, Section 1, to ensure that the actions, discussions, and records of public bodies and their accountability to the people are always open and available for the public to see and hear what's going on. And this is derived from Part 1, Article 8 of the New Hampshire Constitution, which mimics the same exact language, that government should be open and accessible and accountable to the people. So when you understand that the requirements of the right to know law emerge from a constitutional right, what we would tell you as lawyers is whenever there is a constitutionally based right, the courts and those who enforce those rights are going to make sure government turns very square corners, because constitutionally based rights are given in the hierarchy of protection of rights, are given great deference by the courts. And as a consequence, like I said, the government is going to be required to adhere to the strict requirements of the law. So you'll see it throughout the cases that are issued by the New Hampshire Supreme Court and by our superior courts. The courts, A, hear those cases faster, decide them faster, and spend a great deal of time making sure the ultimate outcome of those cases are done in the light, making government more accountable and open to the citizenry. So the starting point always is that it's a constitutionally based right. As a consequence, it has certain higher level of protection than other statutes and requirements the government has to follow. The other thing that we have to always point out at the beginning of a presentation of the right to know law is the right to know law is a floor. There are many other statutes and requirements that mandate other forms of means and manners of how public bodies will conduct their business. For instance, the right to know law does not contain a requirement that a government meeting have a posted agenda. In fact, the right to know law only says that a government meeting of a public body has to have notice of the meeting 24 hours before the meeting is held, and that the meeting has to be held in a place where the public can attend. and that the meeting has to have minutes memorializing what took place at that meeting. But there's nothing in the right to know law that says you have to have an agenda. There's nothing in the right to know law that says you have to post notice of the meeting 7 days before the meeting, or in a newspaper, which is the requirement, for instance, say if you were having a zoning board of adjustment hearing. It is the floor. But one of the things about the statute is this language, and that language is important because it says in this section of the statute, 91A2, if your town has adopted a set of procedures that govern a public body, it could be town council rules of procedure, it could be land use board rules of procedure that govern how that particular body operates. If those rules of procedure have higher standards for how you open your meetings, or how the meetings have to have agendas, or whether people have the right to speak at public comment, those rules become your local right to know law. So whenever you have such procedures, understand you're in effect creating obligations which are tying back into the right to know law that the public has the right to enforce. So if I have a complaint about the fact that the town council in Londonderry, if they had a council rule that required, I know that this is true for a town that I represented, that any agenda item that was going to be heard by the council had to be published in an agenda posted in 2 public places 72 hours before the meeting, and no subject could be heard at the town council meeting other than what was posted in the agenda. If I'm aggrieved that an item was brought up not on the agenda, I could sue under the right to know law and say that you are violating the right to know law under this provision, even though the right to know law doesn't have that provision in it. So it's when you write rules of procedure, which you should, and we'll talk about that, understand that implication is it ties back into the ability to enforce it under the right to know law. So what is a public meeting? Well, a public meeting is any time a quorum of a public body convenes so that it can communicate contemporaneously to discuss or act on matters over something over which the public body has jurisdiction or advisory power, control, or supervision. Those are the essential requirements of what is a public meeting, which then mandates that the public meeting requirements of the right to know law be observed and adhered to. Quorum, public body, convening for contemporaneous discussion on matters within the board's jurisdiction. So if, and we'll talk about this because I think your council chair discussed this, there are really 3 kinds of potential convenings of a public body. You could have a public meeting, you could have a non-public session of a public meeting, and then you could have a non-meeting. So one example of a non-meeting, when I was a member of the planning board in Bow, every Christmas we had a Christmas party for the planning board at the chair of the planning board's home. That was not a meeting of the planning board. It was a chance social encounter not convened for acting on matters within the jurisdiction of the planning board. And there are many such other examples that could be given where you don't have a meeting that requires compliance with the right to know law. And it's important to know that a town body could not define the quorum of a public body as less than a majority. So you couldn't, or more than a majority. You couldn't say if you had a select board, let's say a planning board of 7 members, you could not say, well, and normally the statute requires a majority is always the quorum, so a quorum in that case would be 4 members. You could not have a planning board procedure that would say, in Londonderry, our quorum is made up of 5 members. And that would, in effect, allow that board to avoid the obligation to hold a public meeting because it's having less than if 5 members are only a quorum, then you would argue as a member of that board, oh, well, we're not having a public meeting because we only have 4 members present, not 5. In fact, the statute makes clear a majority of members of a public body will always constitute a quorum to make sure that the term quorum always means a majority of that particular public body. So quorum, public body, convening to contemporaneously communicate, to discuss the matters within the jurisdiction of the public body. So we've already touched on this to some degree. There's these other things called non-meetings. So you have a social or other encounter where no decisions are made on matters within the jurisdiction of that public body, not a meeting. It's called a non-meeting. When the town manager and representatives of the council, which I presume is how it works in Londonderry, has a negotiating session with a union in town to negotiate a new collective bargaining agreement, that's not a meeting subject to the right to know law. When you consult with legal counsel, because a town, just like an individual, has the right to the attorney-client privilege, that is allowed to have confidential communications with their lawyer that cannot be disclosed to others. Towns have that same attorney-client privilege. So if you meet with your town attorney to discuss a legal matter and get legal consultation, so long as the attorney is in the room with you or can contemporaneously exchange ideas with you by telephone or Skype or some electronic means, that's not a meeting. And finally, there's political caucuses, so when the caucus of Republicans in the House meet to discuss the Republican agenda, even though that is actually a quorum, the way it works currently in terms of the Republicans being in control of the lower house, the House of Representatives in Concord, that is actually a quorum of the House of Representatives. That is not, in fact, a quorum for the purposes of the right to know law, because it is a political caucus, and therefore it's not subject to having an open meeting because it is a political caucus. And finally, you can have circulation of draft documents, which is kind of a narrow exception. Basically, what it allows a public body to do is at a public meeting, you could vote to delegate to the chair of your body. Let's say the planning board wanted to write a letter to the ZBA, telling the ZBA you were not happy with the ZBA's interpretation of a zoning ordinance in a recent variance decision that was made, and the planning board had voted what the content should be, a touch on these subjects, and then the writing of the letter was delegated to the chair. The chair could write the letter because the agreed content was agreed to at a public meeting. The chair could then circulate the letter to the rest of the members saying, I've written the letter consistent with what we discussed at the public meeting. Is everybody okay with it? And as long as everyone just confirms, yes, this is consistent with what we agreed to at the meeting, that would be a permissible form of consultation through email to confirm that this is a draft document that is approved for issuance as a letter to the ZBA. So these are all non-meetings, not subject to the requirements of the right to know law.
So if they circulate that letter and they believe that it doesn't,
if someone piped up and said, oh, Mr. Chairman, I think we missed a subject, we really meant to also include this subject, I know we didn't discuss it at the meeting, you'd have to stop that discussion and say, fine, we have to reconvene as a public body and then agree again as to what the content should be. So ideally, the circulated document doesn't result in any amendments or edits. It should either be, yes, I'm okay with it, or no, we're missing something, stop the discussion, come back and reconfirm what the letter should contain as content. So it's kind of a narrow way in which you can go ahead and get a document approved without having to wordsmith it at a public meeting, because that can be tedious too, trying to wordsmith the content of a letter at a public meeting. Again, it might be such a time suck, it would kind of lose the attention of your members, which is something you really want to avoid. So yes, that's what it's for.
and if a developer has a design charrette, or if a energy body comes in and wants to, put towers up and has open meetings for people, and all of the planning board shows up, or all of the zoning board shows up, is that a non-meeting as well?
That would be a non-meeting, so I'll give you another example, which is a little bit better. I think it's a cleaner example. I got this question posed to me from a select board in northern New Hampshire. They were told that the Federal Emergency Management Agency was going to conduct a public meeting in their town to discuss new insurance flood zone mapping. So you have this insurance for flooding, and you have to map certain areas with the 100-year flood zone, and FEMA was coming to the town saying, we're changing the flood zone, the 50-year flood zone and the 100-year flood zone map in your town. There are new maps, new areas are going to be in the flood zone. Let's have a discussion about it. FEMA's running the meeting. The select board decides to go to the meeting because they think that's an important for them thing to know. They're there not to act on matters within their jurisdiction, because the select board cannot vote to approve or disapprove a flood rate map or a flood zone map published by FEMA. They're just gathering information. That's probably similar to the planning board attending, say, a charrette put on by a developer who's going to be proposing, let's say, an energy facility, although it's a little bit more likely to be within the planning board's jurisdiction because it might come to the planning board as a site plan in the future. So my example is, I think, is a little cleaner, and it is cleaner when the thing that the board who is attending, what the other body is doing is not within their jurisdiction.
Right, but what if it is within their jurisdiction? Does
Then it becomes a
fall?
little closer question as to whether or not they're going to be engaged in some kind of activity which could be considered supervision or discussion on matters within the jurisdiction. I think the safest route, if the planning board's going to attend a meeting like that, is to simply to avoid interactive discussion among the board members themselves, so there's no contemporaneous exchange of information, and just treat this as an information session so that the members are gathering information and not consulting with each other and looking like they're carrying on a little mini meeting at someone else's meeting. And that would avoid the implication that it's a meeting that they had to post. Now, realistically, if you have any doubt, just post it as a meeting. Just say, there's going to be a quorum of the planning board at this meeting of XYZ developer who's going to build a new gas plant in the town of Londonderry. And they'll be all sitting in the back of the room, and then you've posted the meeting, and you've dealt with any potential implication that someone could argue that had to be a posted occasion.
Thank you.
So all of these are non-meetings. Now, when we look at meetings in terms of breaking them down into two different parts, one of the things that we thought was useful was to break them down into two parts with regards to what are meetings and what are hearings. So typically a meeting is when a board or a committee is conducting its business to discuss or evaluate issues that are before it. And generally, when the board is holding, say, a planning board is holding a business meeting and they're not holding public hearings, the ZBA could have business meetings, Conservation Commission have business meetings where they may be discussing the rules of procedure, they may be having a workshop. I know in the town that I represented in southern New Hampshire, typically the planning board would have what they would call a work session on the first Thursday of the month, and then the third and fourth Thursday of the month was their public hearing nights. So they're technically at their work sessions, they were either having presentations by the engineer about a new drainage study, or they were discussing among themselves zoning amendments, et cetera. That's a business meeting, it's not a public hearing. And so you're just acting on matters within your jurisdiction, and you would not necessarily be required to give notice of that public meeting as required, say, under the planning board statute, RSA 676:4, the statute that governs most of the planning board's procedures, or for that matter, the zoning board of adjustment or other public bodies. You would just be using the right to know statute, which would require 24 hours notice, which we'll get to in a minute, of the fact that the board is holding a public meeting, and if your rules require it, a list of agenda items that you're going to address that particular meeting that night. Now, under the right to know law, you would give notice. The board would be meeting to act on its agenda. The board typically would not be taking public comment or public input, or it could have that option if it wanted to, but it's not a public hearing. But it is a public meeting, so the public can attend. And as is true with every public meeting, when the public attends your public meeting, they can record what's going on. They can take out an audio recorder, a video recorder, and they can record the entire meeting in any fashion they wish. They don't have to have permission to record the meeting. They can photograph the meeting. And as long as they're not disruptive, they can use any means to record what takes place at your meeting. That finally, as a public meeting, once you've had a public meeting, within 5 business days, you have to produce minutes. And then, of course, there are public hearings. That's to act or hear public input on a specific issue. So if it's a planning board site plan, if it's a notice public hearing, you're going to hear from the applicant, you're going to hear from the abutters, and you're going to also hear from other parties who have an interest in the outcome. Now, I don't know how strict or stringent the rules are for your particular land use board. Some land use boards really don't get into the business of, are you an abutter, or are you someone who has an interest in the outcome? You might just allow whoever comes up to the microphone to speak. That really is up to the planning board But there is, in fact, a statutory list of those who are required to be heard, as there is one for the Zoning Board of Adjustment. So this is kind of like 91A plus in terms of what are the things you have to do to give notice to the public. So the planning board has a 10-day notice before a public hearing, published in the newspaper in 2 public places. Zoning Board of Adjustment has a similar requirement, 5 days. The council might have a requirement to give notice of public hearings on the proposed adoption of a budget by statute or by the town charter. So there's many other statutes that would dictate different levels of notice. That's why we call it 91A plus, because it's more than just 24 hours notice posted in 2 public places. It may include notice by certified mail, it may include notice in the newspaper, et cetera, et cetera. So there's a higher level of notice required. It also is open to the public, so the public is going to be, again, participating and able to attend, and they can do all that recording and other such, able to have a recording of what took place at the meeting. But then you also have this other layer of obligation to listen to the public. So, as I said, public hearings, that's the idea. The public has a right to be heard. And we'll talk about the kind of things that are useful to set as ground rules for when the public is participating, whether it's public input or in a public hearing. Now, for a planning board, typically when you're having a public hearing, you're going to have rules of procedure that govern how the planning board does its job. I'm probably more familiar with planning boards, given that I was on the planning board for 12 years. So the rules would say the applicant will make the presentation. Then once the applicant is finished, then there'll be an opportunity for abutters to make their voice heard. And then you might have the opportunity for the applicant to respond to the abutters, or sur-rebuttal, as the case you might want to refer to it. And then the abutters are able to come up after the applicant has responded to their statements and respond to those responses. And it really depends upon how far back and forth you allow that to occur. So you would have a set of rules that would govern how that process works. You might even have rules that set time limits on how much time can be allocated to the initial presentation by the applicant, or how much time is allotted to abutters if they're an organized group, or if they have representation by council, how much time they're allotted, so that there's a fairness in terms of the division of time that's allocated for the public hearing process. So you have really a different set of requirements for hearings and public meetings. And our point here is to point out there is a difference between the two. Again, keeping in mind the right to know law is always a floor in terms of notice, but the right to know law, again, if I haven't said it already, does not contain a requirement at public meetings that the public has a right to be heard. There's nothing in the right to know law that says a person who attends a public meeting has a right to speak or a right to make a presentation. That is only triggered by another statute, or many towns have rules of procedure that will allow the public to attend public meetings and give public comment. And we'll talk about public comment a little bit more a little bit later. So, as I've already pretty much touched on, what are the basic requirements of a public meeting? So you have to give public notice. You have to have it open to the public. And by the way, when I say open to the public, that's not just residents of your town. That's anyone who is here and wishes to be present to your public meeting. It could be non-residents. It could even include non-citizens of either this state or the United States, because it's just the public who has a right to attend. And those people would actually be considered members of the public. If the statute said only citizens could attend your public meetings, that'd be a different story, but that's not what the statute says. It says the public has a right to attend. And finally, you have to produce meeting minutes. There are different requirements in the RSAs, especially for land use boards, as to when they have to produce a definitive document, such as a notice of decision or minutes of this meeting that memorialize a notice of decision. I'm not going to be able to regurgitate them by memory, but I believe the ZBA has to generate a notice of decision within 72 hours of its meeting. But for the right to know law, anytime a public body meets, you have to produce minutes within 5 business days. And that 5 business days, not including Sundays and holidays. Yes, in the back.
Do you meet that requirement by putting draft notices up and then the drafts of the minute and then putting them, you meet that requirement and then you can put the final minutes later?
Absolutely. You can meet the requirement by producing whatever would be a fair representation of what took place at that meeting.
Is there any time limit after the drafts go up that the final has to be put up? Is that
No.
just-
Realistically, the right to know law does not discuss or address what is considered the approved minutes or draft minutes or minutes. What the right to know law just refers to is minutes. The town public body has to produce minutes within 5 business days of its meeting. So in terms of the preparation of minutes, we generally provide the following recommendations. Unless a public body is prepared to meet within 5 business days of its meeting and approve the minutes, you can't conceivably be able to produce in final form with every member having the opportunity to review them and agree as to their final content within the 5-day business period of time. It's just not realistic. You'd be having way too many meetings just for the purpose of approving minutes. So realistically, you have to have some kind of process where the person who's taking your minutes can produce a reasonable description and representation of what took place at your meeting. Now, one of the ways that I've seen one town do that, which I think works very well, and one planning board I represented, what they did, and this was just to comply with the right to know law, and this was a planning board that would sometimes generate long, what I would call transcript-like minutes that would go on for 20 to 40 pages. The day after the planning board would meet, staff would prepare a document called minutes decision. And it was simply the bare minimum required under the right to know law. And the right to know law just says you have to, in your minutes, list the members present, the names of people participating, which means anyone who spoke and gave their name and address. Their names have to be in the minutes. It has to list the subjects discussed and decisions made. That's the bare minimum. And so that planning board would have staff produce a document that just did that. It would literally be, the person would take the agenda, insert, the actual names of people who participated, insert the actual names of the members present, and then if any decision was made, they would memorialize that in a couple of sentences. And that document would typically be produced and put online the day after. They've complied with the right to know law. Go ahead, yeah.
Do you meet that requirement by posting it on the community website?
Well, the statute, what the statute requires, it has to be available for public inspection within 5 business days. So if you put it on the website, it's available for public inspection. But it should also be available someplace here at Town Hall so someone could read it. Ideally, it should be in a binder or somewhere someone could actually look at it. So just to complete the story, yeah, go ahead.
If you put it in the town hall, can you skip the website?
Maybe not. Only reason I'm saying that, there's a new statute that's about to be finally approved by Governor Sununu, which is going to say that if you are currently posting your minutes on a website, you have to continue to do so. You can't stop doing it. So I can't tell you that you can stop using the website because that may be a mandate if you are using it now. So, but again, the right to know law just says produce them and make them available for public inspection. So, like again, this planning board does exactly that. Staff does it for them. Boom, it's done. About sometimes 3 weeks, sometimes 3 months later, they have a much more detailed set of minutes called the transcript that the board would ruminate over many months and finally approve in final form. And that would have a much more detail about that meeting. And that was invaluable to me as town council because that's where I usually was able to defend the town in terms of how the decisions were made, but it's all in the transcript. So that's one approach that you could, in terms of complying with the right to know law. Yes?
We write up the minutes, but we don't approve them until the next meeting, which is typically a month later. So is that the wrong way to do it?
No, you could do that, but understand that the minutes that you've produced, those are your minutes. Now, later on, a month later, you're going to sit down and say, wait a minute, that's not exactly what we thought took place. So what you then do is members are going to vote to amend the minutes which were already produced. What we think the better practice is, keep what was already produced. Those are the minutes. Now you're at a meeting a month later. and you would vote, Mr. Chairman, I think that we should make the following edits to the minutes, and maybe just one or other people make the same motions. Those edits appear in the minutes of that meeting, and they stay in those minutes. And then if you wanted the full understanding of the two, you'd have to compare the two and put them together, rather than changing what was already produced within 5 business days.
But the approval of the minutes should be done, I'm not talking about changing, I mean, the approval should be done within the 5 business days, no.
It doesn't have to, because
doesn't have
you
to.
can't realistically do it. I mean, you have to, the board would be holding all these additional meetings to approve minutes. And there's nothing in the right to know law that says you have to approve minutes. It's not in the law. It just says you have to produce minutes. And again, keep in mind, all you have to produce is the bare minimum. And you could have a much more detailed, separate set of transcript-like minutes, which contain all these details, which may be material to defending your decision-making. Yes, in the back again.
2 things. One, so if you have a quarterly meeting, as long as you approve them at the next meeting, you're within compliance because you approved them at the next meeting.
You don't have to approve minutes. That's the key thing I want to say. All you have to do is produce them within 5 business
You
days.
see, where in the town does the statute say these minutes have to be for the person to know where to go look for them?
Well, in most towns, and everyone's a little bit different, the town clerk is the central repository of official records of the town meeting or of the town boards. But realistically, I also know it doesn't work that way. So land use boards, you probably have a community development department, and all the minutes for the ZBA, Conservation Commission, Planning Board are over there. You probably have a town council office where the town council minutes are over here. If you were going to be super accessible as an organization, a public body, one of the things you could do is say, we're going to have one place in town hall where all the stuff is kept. And it's going to be called the Public Records Reading Room. Now, in fact, that's exactly what the Department of Environmental Services does. You go to the Department of Environmental Services, you want to look at a public record, they have a public record reading room. And in that public record reading room, they have all these binders. This is the binder for the minutes of the Wetlands Council. This is the binder for the Council on Solid Waste. It's all the stuff is right there. So if I wanted to dream up a truly open and accessible government, that's what I would create. I would create a public access room. It's a room over here where all the records are kept. Anyone who wants to know anything about town, business, and public meeting minutes, they'd be all in one place. And maybe there'd be a computer terminal there where I could sit down and log on and read stuff. Just a suggestion, but typically it's the town clerk where the stuff is kept. Yes?
With new technology advancements, we record almost all of our meetings. We have to literally put it in writing. You can't just say.
You can't have a recording.
So that's nothing about it, so they're not
There
required.
is
you don't have to
no,
have it, it's just-
nothing in the right to know that says you could substitute a video and audio recording as minutes. You still have to have minutes. It's still a requirement. So we've already pretty much talked about the obligation to give notice. So the minimum of the right to know law is 2 public places, 24 hours before the meeting, unless there's an emergency. And if there's an emergency such as, you know, a huge dam is broken in town and some part of town is going to be flooded and the council has to meet on an emergency basis to authorize certain emergency activities by the Public Works Department, and there's less than a 24-hour period of time in order to make the decision, the council can hold a meeting in less than 24 hours' notice, and it would put in its meeting minutes, we held this meeting on less than 24 hours' notice. We did give notice as best as we could on the website elsewhere, and these are the reasons why we had to hold it on an emergency basis. Yes?
Just take you back for a minute, stupid question. So if an organization didn't approve the minutes, they would not be in violation of any law as long as the minutes are out.
Exactly, because there's nothing in the right to know law that says you have to approve minutes. It just doesn't exist, and people think that that's required by the right to know law, but it's not there.
So
All the
if you left
statute,
audio minutes, if you had audio minutes down and you had left them draft for the next 10 years, you'd be in compliance.
there's no problem. Now, your members, as members of your board, again, thinking about trying to keep them engaged, if they become upset because they don't think the minutes are truly reflecting what's going on, then at subsequent meetings, you'll revise them and create amendments through subsequent meetings to reflect those changes. But the right to know law just says produce the minutes within 5 business days. That's all it requires. So let me just kind of segue into another area, which we're also going to discuss, how to have, well, actually, before I get to that, I see I have a section here in my materials I want to discuss, which is continuing and canceling a meeting. And this is a question that's come up a lot recently, so I want to mention it. It certainly came up when there was issues arising out of the decisions by some town moderators to postpone town meeting this past March as opposed to holding the town meeting during a snowstorm that was of such a record nature that was significant concern for public safety. So when you're talking about canceling a meeting, which can happen due to a number of different circumstances. I've seen meetings canceled, but too many people showed up, and they had to get a different hall to hold the number of people who wanted to attend. They have to cancel a meeting because somebody they don't have a quorum, or enough members didn't show up. There could be a number of different reasons. So the public body, if it has a situation where a meeting has to be canceled on the night of the meeting or the day of the meeting, you really have to take steps to notify the public as quickly as you can. So you would use your website, you would post notices at the original meeting place, and maybe even make telephone calls to significant participants to let them know the meeting's been canceled. So there is no statute that mandates this is how you cancel a meeting, but there are steps you can certainly take to accommodate the knowledge to the public that the meeting's been canceled or participants. Continuing of a meeting is also a subject which has recently been addressed by the legislature. Planning boards for many years have had the ability to, under RSA 676:4, when they're already at a truly already noticed public hearing, with notice to abutters by certified mail and posting in the newspaper and published in the newspaper, if the planning board gets to the end of such a public hearing and has to continue it to another date, the planning board can say by statute to those in the audience, we're going to continue this public hearing to another date, time, same place. And they don't have to re-notify the abutters or the public because they did it at the meeting. That's a statutory ability to give notice of a continuation. The ZBA now has the same authority. In fact, it goes into effect the first week of August. So there's legislation that was adopted that now allows the ZBA, because it gets to the end of a public hearing night and it's 1 o'clock in the morning and they want to continue it to another day, they don't have to give new notice to abutters or in the newspaper. They can continue it to say, we're going to continue this public hearing to a new date, time, and place. Yes?
Prior to August, what do we do?
Well, you comply with the statute. And this, what we've always been telling people under the statute, you have to, let me just double check the effective date. I don't have it in my notes here, but I know the statute went into effect, it was 60 days after June 21st, so I think it's going to be like August 21st when the statute goes into effect. But don't hold me to that, we would want to double check. I think it's SB 86, if I'm not mistaken. So what we've always told ZBAs is, unlike the planning board, you don't have this authority to continue a public hearing at an existing public hearing. So you really have to re-notify. And I think that's part of the reason why the legislature changed it to make them a parallel process. Both boards, once they've had a truly noticed public hearing, can then continue it to another date by giving an announcement at the existing public hearing. So spend a little time now talking about how to prepare to have an effective meeting. And I guess really the starting point is, do you have rules of procedure? Land use boards, all land use boards are mandated to have rules of procedure under RSA 676:1. So I'm sure your land use boards have rules of procedure, your ZBA probably has them, your planning board probably has them, Conservation Commission, I'm sure your council has them. In fact, the council may have rules of procedure which are dictated in your charter. So there are a number of ways in which the organizational structure of a meeting, or how that public body will conduct its business, will be laid out in rules of procedure. And so what are the kinds of things that you would want to see in a rule of procedure? Well, among other things, you would probably want to have to say who are going to be the officers who would run this particular public body: chair, vice chair, secretary, etc. What is the authority of the chair? Can the chair set the agenda? Can the chair add agenda items? What are the things and how are the agendas assembled? Who is that obligation? Does staff do that? Does the chair do that? And how does the chair consult with the rest of the members if a member wants an item added to the agenda? These are all things you would probably want to have covered in your rules of procedure. You also would probably want to have addressed such things as what's the process of, do you have a rotating list of alternates and how the alternates are appointed by the chair? In fact, by statute, alternates are always appointed by the chair if you're a land use board. But if you're not a land use board, and if you have alternates, let's say on the Conservation Commission, you would want to have rules of procedure that defines how an alternate would sit when the Conservation Commission is going to be taking up public issues. And there are many other things certainly you would have on an agenda, rules of procedure. In addition to the agenda, you would have, how does the board get a notice of information that the board has to look at before a public meeting? Packets. I know in one town that I represented, they had a process that was in its rules of procedure that said, if you have an application to be heard by the planning board on a certain date, whether it's a public hearing or other presentation, you had to have the materials to town hall on the Thursday before the meeting, which was always on a Wednesday. And if the materials were not delivered to the board by that time, which is the time when the staff was putting the packet together, because the packet would actually be hand-delivered by the police department to all the planning board members on Saturday, if it wasn't in the packet, it wasn't going to be heard by the planning board, and the document would not allowed to be introduced at the planning board meeting the following week. And there's a huge benefit to having that kind of process involved, because I can't tell you how many times I sat at a planning board meeting, and the applicant would say, "Oh, Mr. Chairman, we just got this traffic report from XYZ engineering firm. I want to hand it out to the planning board." And there's nothing more difficult or disconcerting to be having a public hearing going on, and you've got a 15-page, single-spaced traffic report that you're required to look at, digest, consider, and take into account while you're having a public presentation. It's not fair to the applicant, because you're not going to give a fair understanding to what they've just submitted, and it's certainly not fair to the planning board members, because they're not going to be able to digest the information. So that's, again, something you might want to have in your rules of procedure. A public body requiring a cutoff period. Paperwork have to be into the planning board or to the land use board or to any other board within a time period prior to the public meeting, so that a packet is going to be sent out to board members, they can have a chance to digest it, and they don't have to sit at the meeting table trying to read and listen at the same time. Very difficult thing to do. So when you're organizing your agenda, there's a couple of things you should think about in terms of how the agenda is organized. You're going to probably have a need to set up allocated time periods for when, if you're going to have an agenda that's going to have public process taking place, that is public meeting taking place, and then public hearings, you'll probably have to set timetables within the agenda. This public hearing will start no later at this time. So you have business going on, say consent items are being discussed, or you're discussing minutes, as the case may be. Your agenda might state, this public hearing will start at 8 o'clock, so that both the applicant and the persons who are interested in that agenda item can know that's when the item's going to take place. You probably have to think about having that kind of process where you indicate in your agenda when things are going to be reached. You probably also want to think about having a consent agenda, so you can allocate time to things that no one really is going to spend a lot of time discussing. A lot of governing bodies have consent agendas, so they'll have a whole list of what everyone concedes are appropriate abatements to grant, or other forms of approvals, permits, parade permits, any number of different things a governing body would issue. You have a consent agenda, so that those are just addressed with one vote by the entire board on all the items on the consent agenda, unless someone pulls something out for separate discussion. Those are appropriate procedures you might want to have in an agenda process. Yes?
On the agenda item, what about, I've seen this a lot, where they take something at the end of the agenda and move it to the front? Is that, allowable?
You would probably want to have that in your rules that say a member can move to have an agenda item moved to a different time, depending upon the circumstances that might arise. So if an applicant notifies you that, yes, you have this scheduled to start as a public hearing before the planning board at 8 o'clock, but I've just found out because my traffic engineer was in an auto accident, no irony intended there, and so they have called in by cell phone, and my traffic engineer won't be here till 9 o'clock. So the chair would entertain a motion to delay that matter for an hour. Now, the abutters all may groan, because then they have to stay another hour later, and those are just decisions you have to make on the fly. But having a process that's flexible certainly makes sense, because you never know what kind of contingency is going to arise, something like that.
But you have to have the motion.
You would have to have a motion, yes. And again, these are things you could lay out in your rules of procedure. Yes?
So what if your estimation is that you're gonna start something at 7:30, but you got done with everything else before that by 7:15? Do you have to wait till 7:30 to start?
If your agenda was really clear that the item was not going to occur at that point, you would have the danger that those who wanted to be heard suddenly wouldn't be able to attend because they thought it would start at 7:30 and they're going to show up at 7:30. So you certainly have to be sensitive to, we've gotten so fast in terms of the process of dealing with the consent agenda and the easy items that we're going to have to take a break until we can start, because we've told the public at large this public hearing will starting at 7:30. In the back, yes. No, you're all set? Okay. Yes, go ahead.
I'm going to go back to circulating materials in advance.
Yep.
If planning board gets some information ahead of time, can they ask the planning department to explain something about it?
Typically, I think if an individual planning board member, not the whole board, if you call the staff and say, what is this, that's perfectly fine. You want a clarification of what the document means or what its importance is, that certainly makes sense, yes. You can certainly have something that would allow that to occur. There's nothing to prevent one board member from contacting staff, or for that matter, coming to town hall, asking a question as to what a document, what's the import of a particular document. So going along the lines of, getting packets of materials to board members beforehand, that also touches and concerns the duty of the board members to read the materials, to be prepared. And being prepared for your meetings is an important part of the process. So reading the minutes, if they're included in the packet, reading the reports, typically for a lot of land use boards, certainly here in southern New Hampshire, you have staff. And for the planning boards I represented, staff would usually prepare a staff report for every application. So the staff report would have a summary of the key items that were in the packet, whether it's an engineering report from your engineer or an engineering report from the applicant's engineer, and that serves as a basis for the board to summarize, have the board have it summarized to them. But ideally, you've taken the time to read the materials. And again, I understand that's taking away from your time, from your family, the things you'd rather do. But the purpose of getting the packet beforehand is to allow you to digest the information so that you can filter what you're going to hear at the public hearing through the data that you've received beforehand. And if you're at a public meeting and trying to read documents, it's a very difficult process to participate if you're reading and digesting and then trying to listen to the public hearing at the same time. Yes?
So sticking on this theme, if someone does come to the meeting, they have a new traffic study, and it's quite long, do you continue the meeting to the next scheduled meeting and give everybody a chance to digest it?
You could do that. You could say that that is the outcome, or you could say, no, Mr. Applicant, you knew our rules. Our rules were you had to have the report to the town hall the Thursday before the meeting. You didn't do that here. And as a consequence, we're not going to consider that traffic report. Or, at your expense, we'll continue this hearing. Let's assume it's a planning board, you can continue it. But you, applicant, if you were going to force us to continue the hearing, you have to give us more time under the clock, because planning boards have a duty to accept, approve, or disapprove plans within 65 days of plan acceptance. So if you're going to delay things, that's up to you, but that's going to require you to give us more time. We want another 60 days or 90 days on the clock to meet our deadlines under RSA 676:4. Now, the downside here, if you do that, and then people will, in the audience, if you have a very contentious application, the abutters are going to groan. Why are you giving them more time? You're just bending over backwards for these people. And it's what's that?
I said, have you been watching our meeting?
No. I've been to enough public hearings to know that's how it goes. So as a consequence, it is, you have to really drive home to the applicants. We know your time is valuable. We know that, if you show up with a traffic engineer, a civil engineer, a noise engineer, and a landscape architect, the clock is running for them at, $300 or $400 or $500 an hour. So if they're going to waste time and money, that's their business. But, you know, respect the time and energy of either, A, the volunteers who've showed up to do their business on the planning board, and also the audience. Respect their time. Don't waste their time. So I think that if you have a rule that forces parties to recognize that obligation, you might avoid situations where there's going to be a last-minute report. On the other hand, it is always going to be true that there's going to be exceptions to the rule, where you might have to yield in special circumstances. And I can't really predict all the reasons why, but there might be a legitimate reason why it really has to come in at the last second. And you might be willing to bend the rules in that particular instance. So it's going to be a judgment call. But, you know, what I saw of the planning board that I represented that had that rule, it worked pretty well. And the stuff got in. And everyone was aware of the requirement and adhered to the obligation to get things beforehand. And as a consequence, I think the planning board, when it was making a decision, was better informed. And we're not having to read reports during the process of doing a public hearing. So let's talk a little bit about conducting the meeting in order to comply with the right to know law. And I think I've already discussed this kind of at length. So like I said before, the public who attends your meetings, they're any member of the public, and the public is not defined as citizens only, or it's not even defined as residents of your town. So the public can really be anyone who walks through the door and is sitting in your meeting. And open means anyone can attend, and they are able to, again, videotape, audio tape, and record as long as they don't disturb. And when you are conducting a public meeting, there's no such thing as secret balloting, unless you're in a non-public session. But one of the attributes of a public meeting law is every vote has to be public. When you vote on granting a subdivision application, or the Conservation Commission is going to vote to buy land for conservation purposes, or the town council is going to vote to adopt an ordinance, it's all public votes available for the public to see who voted how. And frankly, I think ultimately it's a good idea to have votes, have roll call votes. Just every time do a roll call vote. And then it's very easy to see how your representative voted. Yes?
Well, while all members of the public can attend, if you're holding a public hearing or engaging public comment, is there any guidance you have about giving priority to abutters, town residents, in some order, or is it just?
Well, I'll get to that in a second in terms of the public process, but let me just say this. If you have a public hearing, it would certainly be appropriate, say, for the planning board, because the planning board actually has a hierarchy of people it has to allow to be heard. And I believe what the statute says is the applicant, the abutter, and those who have an interest in the outcome. And I would put that as a hierarchy. So it's the applicant first, the abutter second, and those can show they're affected by the application. I would certainly file that hierarchy 1, 2, 3. Now, if you're just holding a public comment period, if you have a public comment period for the council, and a lot of public comment periods is, you have rules of procedure, we'll talk about that, anyone can come to the town council, you would like to probably limit public comment to things which are on the agenda, so we're not going to discuss, the climate in Madagascar, we're going to discuss items on the actual agenda for the town council that night, so someone can come and talk about those things. Typically for a public comment period, you would have a sign-up sheet, and the first person who signs up is the first person who's asked up. And you really wouldn't distinguish, is that person a resident or not a resident. For a planning board and a ZBA, it might be a little bit different. Yes?
How do you do that if public comment is the first 15 minutes of the meeting?
Yes.
You got 5 agenda items. The last agenda item is something contentious. Too bad you can't discuss it because public comment was beginning, but you can't public comment about something you haven't heard yet or you don't like when you hear it at the time, because public comment was 2 hours prior to that 5th agenda item. Is that legal? I mean, what do you just say, too bad, wait till the next month's meeting, and at the beginning when we have public comment, you could discuss what was discussed on the meeting before?
Well, I mean, there's a couple of things I would say about, when you're going to manage the rules of procedure for your public comment period. Number one, I'm not sure it's a good idea to have public comment period the first thing on the agenda. I think it should be either halfway through or at the end. I think halfway, a lot of boards will put a public comment period, they'll have 2 public comment periods, one halfway through and one at the end. So I agree with you. If you have your public comment period up front and everyone was waiting to hear this contentious item number 5, and then you don't have a public comment period after item number 5 is heard, there's someone's going to say that's a really not fair public comment process. But it's not illegal. There's nothing wrong with it. There's nothing in this law that says you have to run your public comment period this way. In fact, there's nothing in the right to know law that says you have to have a public comment period at all. But what I'm pointing out is you want to have one that works for the public. You don't want to have a public comment period when people think, well, they don't really want to hear from us. They just want to have us be heard, and then they'll do their business, and we can't really comment on what they just did. Because that looks like you don't really want to hear what the people thinks about what you just did at that public meeting. But that's a public procession. It's not a legal one. And again, what I'm pointing out is, open government should have procedures that engage the public, not treat them as someone we just want to get around and they're just kind of an annoyance, I guess is the point I'm trying to make. Yes?
But the public should only be speaking on anything that's on that agenda.
Yes, but I'll get some more detail about some actual specifics about how public comment period should be handled. Typically, it is a good idea, and this goes into your rules of procedure, that if you're going to have a public comment period, you say in the public comment procedures, and you make that clear, you're going to have a sign-up sheet. Here's the public, you can sign up here to be a public comment, and right next to that, you have the rules laid out in bold print, 24 font type. Speak on items on the agenda. You have 3 minutes to speak. If you want to speak on something not on the agenda, you have to alert the chair beforehand, and we have to agree that's what you can speak on. So you have written rules that people know those are the rules of the road. Yes?
Seems to me if you should be able to have a public comment before each agenda item. Wouldn't that solve the problem?
It could, but think about how that might...
Well, especially if you know something's going to be contentious.
Well, yes, but if you're a public body that's not requiring to have a public comment period, let's say the town council, it's a little bit different from the planning board. If planning board's doing a site plan or subdivision, you're going to hear it all out at the public hearing process. But we're talking about a board that's holding a public meeting that's not required to have public input, just having a public meeting. I just would say if the town council would have to take public comment after each agenda item, you'd be here till the cows come home. Now, one of the things I would say, and you've all seen this, in a lot of town council meetings, there's 1 or 2 people here, and it's the usual suspects. And they're always at public meetings, and they're always going to raise their issues, which is fine. I mean, God loved having those people who are being so engaged in government, they're watching every public meeting. But realistically, if you had a public comment period after every agenda item, I think it'd be difficult to get through the agendas, especially if you have a long one.
What I was saying essentially, you have your public comment at the beginning or the end, wherever you have it. But if you know there's a contentious item, you could put a third public comment in.
Absolutely. And again, that's the discretion of the chair. And that may be called upon, and the chair has to exercise its discretion, which you might want to put in your rules of procedure. The chair can exercise discretion to add additional public comment for an agenda where an item on the agenda is going to generate additional interest or maybe require more time for comment. So certainly you can do it that way. I do want to mention remote participation. So there's a process under the right to know law where a member who cannot physically be present in the room, I'm a member of the planning board, but my mother is really sick out in California, I've got to go out and take care of her. But I want to be able to participate in that planning board meeting on that very important site plan for the new Walmart in town. The board can agree to let me participate electronically, but there are some very specific rules. One, the board has to agree to do that, and usually you should do that in writing. Again, it would be something you would cover in your rules of procedure. It will allow a member to participate electronically. Number 2, you have to have a quorum of the planning board at the physical location. So if the planning board is meeting in the town of Bow, the planning board's quorum has to be there, and I'm in Thousand Oaks, California, talking to you by cell phone or conference call. Yes?
Does Skype change that at all?
No, same thing happens. Skype is the same. It's just another means of electronic participation. And so you have a quorum of the board at the physical presence. The member participates electronically. The member's presence has to be not reasonably practical. And that makes sense because I really have to take care of my mother. I'm the only son who's there to take care of her because she just had a broken hip. And so I got to be there. The process has to be that everyone in the room has to be able to hear me, so the device that's used to project my voice has to be heard by everybody in the room, and the device also has to be designed so that I can hear everything that's going on in the room. And finally, when someone participates electronically, all votes have to be by roll call vote. So there is some flexibility that the right to know law applies to those unique circumstances, that you can let a member participate electronically, RC 91-A:2, Roman 3. Another set a slide here about conducting a public meeting. So I've already kind of addressed this, but being on time and showing up on time and starting on time is really critical. When I did occasionally chair the planning board meeting, the meeting started at 7 o'clock. I felt it was my duty. I had a contract with my members, with the participants and the abutters. The contract was the agenda. And I'm going to make an agreement by starting and abiding by the contract that I'm making with the audience, with the persons participating, my members. We're going to start on time. I'm going to stand up, speak up, and when I need to, I'm going to shut up and make sure that we get through the agenda, because that's my obligation as the chair, to make sure we march through the agenda and everyone is heard and heard efficiently, but we're going to start on time, so we're not wasting anyone's time. We're not wasting the board member's time, so we're not wasting any member who's an applicant or is appearing there. The chair's responsibility with regards to every public meeting is basically run the meeting. And again, as far as I'm concerned, I'm making an agreement. I've got a contract with those who are in the attendance, who are on the board. I'm going to follow the agenda. I'm going to make sure people stay on the agenda. I'm going to make sure we not wander from the agenda. And if we can make a decision, we'll make it tonight. And as much as possible, move forward to get to the business. For a planning board, it was always, are we going to approve or disapprove this subdivision or site plan? That's really the important process you want to address. And if you have to make a decision, you make it. If you have to wait, then you put it off. If we can make a preliminary decision and get some of the items on the approval process out of the way, let's do it. If the Walmart can have 20 outstanding items that have to be addressed, let's get 10 of them taken care of at a public meeting, give them give a preliminary approval, so that we don't have to address all 20 every time, so that we're knocking down the particular decision-making process to move it forward to a final action, so that we're not continually hearing the same thing every time, and we come back and we address only things that are remaining to be heard. The chair is also going to designate alternates. Plan use boards, that's particularly true. Only the chair will address alternates. And the chair has the power, which we can discuss in more detail, if someone is being disruptive, the chair has the power by case law to have someone removed from the room who is being disruptive, and is not following the rules of procedure, who is preventing the board from getting the job done. And there's actually a case, State versus Dominic, that addresses that. So the chair's job is really, as much as possible, is to stay on topic. And I think the best way to do that is the chair has to take a Zen-like approach and remove their participation from the subject matter. Even though the chair might be just as concerned about whether that Dollar General is going to be put in your town or the Walmart, the chair really has to take the position, I am not here to act in a fashion one way or another on this application or the matter before the board. My job that night is really not to be an advocate for one side or the other. My job is to get the agenda done and get it done efficiently. And in fact, many boards will have a process where the chair only votes in the case of a tie. So the chair can eliminate themselves from having to be considering as a partisan on one side or the other. So the chair can really focus. My job is to get the agenda done. My job is to get it done efficiently. My job is necessarily, if I have to hear from people, I hear from them, make sure they're heard, and then ask them politely, sit down, let's hear from someone else. And I think that's one of the ways the chair can avoid being seen as someone who is seen as being on one side or the other. Because the more the chair is seen as being neutral, the more actively the chair of a board can participate in a process and not be caught up in the nuances of a discussion or a debate. The chair is floating above it to some degree, just trying to move the discussion along to the decision, whatever it is, to adopt the ordinance, to approve or disapprove the site plan or the variance. I think that's a really good role for a chair to adopt and efficiently get the matters moving along. And as much as possible, once the item is done, say, fine, we've finished with that item, now we'll take up the next item. And to be clear, we've done this item, we're done, and not to allow the topic to be dragged back to an item that's been addressed. And you're moving forward rather than slipping backwards and stepping one step forward and 2 steps back. Yes?
Doesn't that change the whole essence of your quorum?
Not really. You still have your quorum. What you have then is someone who is slightly removed from the tussle that takes place at public meetings, because that person is not as concerned with the outcome, but is more concerned with the process. Clearly, the chair is going to be concerned with the outcome, but is predominantly the business of the chair is to make sure the outcome, the process is done correctly. Everyone is heard fairly, and if need be, the chair can participate and make a decision. But if not needed, the chair can be seen more of a neutral party. And I think that. Well, why would you want to be chair? Because then you would know that your board is successfully achieving the outcome in a way that is not dragging me. I mean, I got to tell you, and by the way, this is just between, well, a point of view I would urge you to keep in mind. All too often in a lot of boards, the person who becomes the chair is the most senior person on that board. And I'm telling you that's a mistake, because I've seen it many times where the most senior person is not ready to be a chair or does not have the mannerisms, the appropriate ability to run a meeting. You really have to choose a person to be your chair who's got the abilities to control a meeting to make sure it runs smoothly. So the chair of a meeting is critical, and a chair who cannot run a meeting effectively, you're going to have a wandering attention of the board, a wandering attention of the audience, and the business of the board will not get done. So I think it's a very important role, and that's why, again, I really think if the chair can adopt that more neutral stance and avoid, being stuck into the nuances of a debate or a decision, you're better served ultimately in getting the business of the board done.
I have a question.
Yeah.
So the procedure, if the procedure has not ever been followed that way, and you want to change it and say that those procedures are written in charter format, how do you go about changing that?
If it's in the charter?
Yeah.
So if your charter dictates a different character profile for a chair than what I've just described, clearly your charter is going to be something you'd have to modify. If that kind of procedure is embedded in your charter is an organic document. It's like your local constitution. There's a very ornate process that has to be employed to modify a charter. So I would say I would like to see a town that has a charter not have that kind of detail in its charter, but if it's there, you'd have to modify it. Ordinarily, what I'm talking about is rules of procedure that would just be adopted by a majority of that public body, whether it's a council or a land use board, et cetera.
The rules of procedure could be changed.
At any time, it would be a rule of procedure adopted by that particular board or body. Talk a little bit about effective meeting and respect and decorum. And I think one of the first things I want to talk about is the cell phone and the iPad and the other devices that public body members have at their side. And if all the public body members are doing this the whole time during a public hearing and they're not actively listening, that's not going to reflect well on your body, or it's not going to appear to the members of the public that your public body is being attentive to the process of the public hearing or what's being said. So I think one of the things to think about is, as much as possible, have your board members put these things away and to focus on what's going in front of the meeting in front of them rather than on the devices that might be next to them. Because it is true, what can happen, and I've heard some board members, well, what What if and you could have a situation where you have that particular public body on television and it's being broadcast live. And the council member says, yes, but I know we're live on TV and there's members of my constituency back at home and they're sending me text messages about what I should do or I shouldn't do. And I want to be able to communicate back with them. I think that's very interesting, but that's not conducive to projecting to the public that you're paying attention. And it's even more problematic because if I see a council member or a member of a public body texting, I might, as a member of the public who's sitting there, say, wait a minute, that's a public record. I want to know what you're receiving. I want to know what you're considering you're making a decision. And when a public body member is gathering information from the internet while they're participating in a public process and then they're going to make a decision, how do I know what was the basis of their decision? Was it the stuff they were picking from the internet on their smartphone, or was it what he should have been listening to at the public hearing, what the witnesses were testifying to with the documents that were presented? So you might want to think about a rule of procedure that says, members of the public body, put your cell phones away. Now, you may have to have a rule that says, okay, the cell phone may have to be on. So if you have a public body member who's got a babysitter with the children at home, they have to be able to get in touch with mom or dad by cell phone, it might have to be on vibrate so the person can deal with the telephone call on an emergency basis, leave the room and talk to the babysitter, as the case may be. So that is one piece of decorum that I think is important to think about, and to probably enforce as a rule that members of the public body should put their cell phones and iPads and other things away and pay attention to what's going on in the room in front of them. Respect and decorum is also very important. And I think for a chair, it's important for a member of a public body to show deference to the chair and also refer to the chair as Mr. Chair or chairperson in an honorific fashion rather than using first names. And to avoid talking over one another or avoid talking over someone who is speaking, and that you take a deliberate process, speak one at a time, not talk over each other, and don't show that you have disrespect for what's going on by carrying on a side conference with someone at your public body. You're whispering with each other, and you're all whispering, and it looks like to those in the audience that you're talking to each other but not listening to the audience of what's going on. So those are things which you can do, not use the cell phone, not carrying on conversations with your neighbor, show respect for your chair, and show respect for your fellow members, even though you might disagree with them, even though you might find them detestable in some fashion, which will project a certain degree of a standard of respect for each other, which will rebound in terms of how it's perceived by the public who are attending your meetings. And I guess finally I would say, think about how you would be perceived if you were sitting in the audience. And just think for a moment, if your meeting is going on, and maybe you think your meeting is not going very well for some reason. Imagine for a moment if you were in the audience. How would you perceive the effectiveness of your public body? Either A, how all of them respected each other and respected the chair in the process, and B, how well they were being attentive to what the public was doing in terms of either presenting evidence or presenting testimony. I think that keeping that in mind may help you instill some attentiveness to the process so that you'll get the business done in a fashion which is giving deference to the interests of the public and also to the process that you have an obligation to follow. Whatever that process is, whether it's a planning board public hearing or a town council adopting an ordinance, or the ZBA considering a variance, as the case may be. I did not include this in the packet. These are not in the slides, but I don't know if you've heard of them before, but there was a gentleman named Fred Riggins who was a chair of the Phoenix Planning Commission for many years, and he put together what's called Riggins Rules. And I think they are really good concepts that public body members should take into account when they're conducting public business. The first of these is, don't mingle with friends, acquaintances, and unknown applicants or objectors in the audience before the meeting. And there's a good reason behind that. You know, if you've seen, and I've seen it myself in planning board meetings, You get the planning board sitting around, everyone is kind of mulling around before the meeting starts, and a certain engineer comes in. Everyone knows that engineer by first name. Hey, Tom, how are you? And everyone's talking, hey, Tom, good to see you. And they're all chatting and they're going on about, hey, Tom, how's your daughter doing? And you got planning board members who were doing that and having this, what appears to be a very cozy relationship with the engineer, who actually turns out to be the engineer. And this is often true in planning boards. It's the same engineer who represents all the applicants in front of that particular board or body. And you have a member of the public who's never been to a planning board meeting before. They perceive what looks like, hey, the planning board, they're really friendly with this guy. And, you know, how do I know I'm going to get a fair hearing when it looks like they're all in a cozy relationship going on between the planning board and this one engineer, whoever the case may be. So it is generally a good idea to keep that in mind. How would it be perceived by that member of the public who's never been to a planning board meeting before? When you're hearing a public process, don't indicate how you're going to vote. You know, adopt a neutral stance to all the evidence you're hearing. Don't indicate, yes, I agree with you, no, I disagree with you. Don't indicate you're going to vote one way or the other. Certainly as part of the public hearing process, you remember the planning board, yeah, I have concerns about the XL and DCL lanes for this particular new Walmart on our, you know, Route 128 in town, whatever the case may be, but you don't have to indicate I'm in support of Walmart or I'm against it. Rotate the seating. One of the things which is true, you could have different planning board members sitting next to each other and they develop kind of, you know, maybe a dominant or a non-dominant relationship with each other, and one person could be seen as strong, another person could be weak. One of the ways to avoid that problem is to mix the seats up occasionally. You know, move the seats around, have different people sit in different areas. And that does two things. It avoids, you know, developing cliques that can develop in a board, but it also forces a board member who has to move from one seat to another to have a different perspective on things, and that certainly can be helpful. One of the things which is, I think, important for a planning board and any board for that matter is don't interrupt the initial presentation. And as much as possible, there's going to be an initial presentation on either an application or a presentation by the audience, by staff on an issue that's going to be heard by the council, or it could be an issue that is going to be heard for decision making. A number of different ways can be initial presentation. Don't interrupt it as much as possible. Avoid, if necessary, interruptions. Only ask for clarifying remarks. I also don't think it's a good idea to use first names. So yes, you know, Tom Hanks has always been the engineer for all of the applicants in front of the planning board. Don't call the person by the name Tom. You know, refer to that person as Mr. Hanks, as the case may be. I think that, again, engenders an understanding there is a more professional relationship with the board and those who are presenting to the board. And don't try to make the applicant or other person appearing before the board to appear to be a fool. I know I've done that myself. I did it one time with a particular engineer who was driving me crazy, and I started asking him very snide and sarcastic questions. And it really was designed to make the person look bad, but it really ended up making me look bad, because I was just using my, you know, ability as an attorney to make this particular engineer look a little silly. And I ultimately probably looked a lot worse than the outcome. So you do, you know, and this was probably, it was 11:30 at night and I was really tired. I wanted to go home and I was getting tired of hearing this engineer, and the chair was probably letting them drone on for too long. But it doesn't help you, or it's something you really should try to avoid. The question in the back?
The only thing I can think that he left off is don't discuss the reasons or any of the effects of the meeting after the meeting with anybody.
Well, I'll get to that. We'll continue on with some of the Riggins rules, which I think are important. So in a process like this, where you have a setup and people are at a podium and they're making a presentation to a board, really don't let them leave the podium to come up and approach the board. There's two reasons for that. When someone leaves, let's say this is the place where most of the presentations were made to the board sitting here, person leaves this board, this place where they're making the presentation to the board is here, and they get close to the board members, the public can't hear as well anymore, and it looks like a private conversation is going on, which has an appearance which is inappropriate. So there may be times where someone has to approach the board to hand something out, But if necessary, I think generally that should be avoided. Don't become involved in neighborhood quarrels if you can avoid it. There are always going to be circumstances where it could be the council, it could be a land use board, it's going to be dragged into a neighborhood quarrel. And sometimes it's the Hatfield versus McCoys, and you're never going to solve the problem. So as much as possible, try to stay out of those kind of neighborhood quarrels if it really doesn't require the board or body who is having that particular presentation to get involved to mediate who's right. Is it the Hatfields or McCoys? You really should try to avoid those situations if you can. Do take staff recommendations seriously. Don't, slough them off. I certainly had planning boards who, for whatever reason, got a bee in the bonnet or burn the saddle with regards to staff. And they started treating staff really like servants and really didn't take stock in what the staff had done. And that's an important circumstance, and it probably is a necessary precondition or pre-step to that particular staff member leaving the employee of that particular town. But staff is there to help, and you really should take their recommendations seriously. They're going to prepare professional reports for your consideration. Take them into account. They're serious pieces of business that should enable you to make a serious decision. Don't try to give the applicant a bone. When you're going to say no to someone, don't say, well, okay, we're going to deny this variance, but we'll let you have a little bit of something. I just don't think it's a good idea. If you're going to say no to someone, don't put a salve on your conscience by giving them a little bit of something which is really not what they want anyway, and it really doesn't solve the problem they had. You should either just be prepared to say yes or no and not try to give them some middle ground, which is what they weren't looking for. When a decision is made, don't show displeasure or elation. Yes, you may have been on the side of the planning board that did not want to approve the Dollar General, but don't clap and say, yay, we've stopped them here. Avoid those kind of disclosure of your displeasure or elation with regards to a particular outcome. And the last and final one, and this is kind of critical, do sit down and have a long and soul-searching session with yourself if you find you're always on the downside of a decision, or you're consistently left in left field, even though, and no one seems to be inclined to take your profound motions seriously. If you are on a board and no one is taking those profound motions seriously, you may have to sit down and look at yourself and say, gee, I have to rethink how my participation in this board is proceeding. And if no one is agreeing to me, if I'm the lone wolf, I have to rethink how I'm participating. And that's something that is worthy of consideration if you find yourself in that particular circumstance. There are a lot more of Riggins rules that are available at the Office of Energy and Planning website, but they're really useful tidbits that are worthy of consideration if you're a public body member. Again, to continue on with the theme, we're weaving in effective meeting with the right to know law. Let's say a few words about electronic communication. So we are at the electronic communication age. We all have the smartphones, emails, texts, any number of different ways we get electronic communication. But there are some really important rules of the road when you're dealing with electronic communication among a quorum of a public body. Avoid substantive discussions by email. If the staff has to send you a document, staff should send you the document and not have the staff engage in a substantive discussion as to whether or not it has a particular meaning as to an outcome that might be forthcoming at a public meeting. It's just a distribution of information. It's not an opportunity to engage in a discussion by hitting reply all. You should avoid as much as possible circumventing the spirit of the right to know law where public business is done at a public meeting with notice to the public. The electronic circulation of documents by email should only be distribution. It should not be a comment period, or we should approve that application, or a discussion amongst the board as to what the meaning is of a particular document. It's only for distribution. A less than a quorum of a public body can communicate by email. But if you have two members of a board who communicate with each other and they say, I think we ought to disapprove the Dollar General site plan, and then the one person, A and B, communicates, and then B communicates to C that I just talked with A, and he's opposed to Dollar General too, so am I. And then C sent an email to D saying, I've just talked to A and B, and they've indicated they are opposed to Dollar General. Pretty soon, you have a sequential series of communications, which is violating the right to know law, something to be avoided. Yes?
Do you see a problem in communicating, one member emailing the chair to ask for an agenda item to be added?
Absolutely not. That's perfectly permissible. What should not happen, and that's the reason why we recommend, if I'm going to, as staff, or even as the chair, to send an email to a quorum of the public body, be sure that the email is structured so that the email addresses of the members are in the BCC line, so that when the person gets it, it looks like it's just to them rather than the entire board. And if I hit reply all, which is the most dangerous button on any email program for public body compliance with the right to know law, if I hit reply all, I do not create a communication amongst the quorum of a public body in violation of the right to know law. It only goes back to one person. And keep in mind always, at all times, when you're doing public business by electronic means, generally those things that you generate are going to be considered governmental records and have to be produced on request to a member of the public who requests them. Yes?
Is there any, as a broker, I have to keep my emails for 5 years. Is there any law or anything in the 91A right to know about how long you should be keeping emails that are part of your business?
Okay, so there's a relationship between the right to know law and the public records or the municipal records retention statute. So they're kind of parallel statutes. The right to know law requires openness in government, and if you have an email and it was generated for public business, it has to be produced. But then the second question is, can I legally delete and get rid of an electronic record? Generally, yes. So typically an email that was sent to you on your personal email account from the town hall to you as sending you a copy of the packet for next week's planning board meeting, you would get it on your personal Gmail account and you would open it up and look at the attachments. You would not be required to keep that as a public record because in RSA 33-A:33-A, 3-A, there is an inventory of 156 separate documents that have to be retained for specific retention periods. So for instance, communication that's considered administrative, and administrative would be a letter by the town council to the town administrator saying, town manager, we've extended your contract for another 5 years. That would be an administrative communication that would have to be kept for 5 years. It would also be part of the town manager's personnel file, which actually has to be kept for 50 years after they've left the employment of the town. So, generally, if it's not listed as a record that has to be retained, such as the email that was sent to you by the town staff sending you a packet, you could delete it, and it wouldn't be...
What about what I send back to...
And what goes back to the selectman probably isn't a governmental record that has to be retained either. So the recipient can delete on not necessary to be retained public records, and as long as they're legally deleted, they don't have to be produced. And legally deleted, by the way, if you want to get rid of an email and not keep it with you, it's not in the retention schedule under 33-A. You have to not only put it in your deleted items box, but then you have to empty your deleted items box, which is always a good idea. Empty those, especially because you might have spear phishing emails. You know what spear phishing is? Spear phishing is when the hackers from Russia will send you an email saying, hi, Uncle Sam, here's some photographs from our vacation in Hawaii. And you say, great, I'm going to open those photographs. And they're not photographs, they're evil malware that's going to take over your computer. So that's called spear phishing, and it's used as a device to trick you into opening a document that's going to then create a piece of malware that takes over your computer. Generally, you're deleting things that you don't want, and certainly that would include things that it goes into your spam folder. You drop them all into your trash folder, and then you delete everything that's in your trash folder. So some general additional comments with regards to tips regarding using emails. Generally, never use emails for matters related to the business and duties of your public body. That is, discussion on whether we should approve the variance or the site plan or approve the ordinance. Use email to just send out information. Tonight's meeting is canceled. The meeting next week has been rescheduled for a different day. Here's a copy of the documents you need for the meeting. That's not a discussion, that is just delivering information to your inbox. Use generally as much as possible when you're sending material to a quorum of a public body, use an administrative staff person at town hall. Don't have the chair do it. Sometimes the chair has to send an email by communication to the entire board, but always use the BCC section of the email program, so no one can hit reply all and create an illegal electronic meeting. As much as possible, try to use official town, city, school, or email addresses. I don't know what the domain arrangement is that the town hall has, but the way it works in terms of the internet, the town gets a domain name, londonderrynh.org, and that domain name is then registered with the domain name registration organization, ICANN, usually it's Network Solutions, and that's used it creates an index that all the routers through the internet, whenever they see londonderrynh.org, it sends it to the server that is assigned for your domain name. So your ISP, whoever is your IT operating internet service provider, they have set up an email account with a certain number of email inboxes, and all those email inboxes use that domain name, and all the emails from the internet that have that domain name use and search the internet and use the indexing system and get it into your server. If you have the flexibility so that each member of a public body can get their own individual email, official email, that's great. But you may not have that flexibility because you may need to have 200 or 300 email boxes, and your ISP may only allocate 100 or 50 official email addresses. So if you can't get an official email address for your public body or your business or membership in the public body, one of the things that I would urge members to do is everyone's got their personal email account where you buy things from Amazon, you send things up to Facebook, whatever the case may be. Don't commingle your personal email account with your public business. Create a separate Gmail account just for Steve Buckley, Bow Planning Board, or Steve at Conservation Commission, whatever the case may be. Create a simple Gmail account and use that Gmail account so that when staff wants to know how to get a hold of you by email, use that as the contact email address. That way, if for some crazy reason some public record is arguably within your inbox, it's not going to be in your personal inbox. Because I actually had a situation where there was a member of a select board who was conducting a lot of public business on her personal email account. And then she wasn't reelected. But there was a lot of still legitimate public records in her inbox. And I had to help the town go back to her and do some professional begging. Please allow us to access to your personal email account. We have an obligation to produce public records in response to a public record request. The town did not have access until it asked permission, and then the person gave that permission, we searched the inbox, and we got the records. You don't want to have that situation, and then you don't also want to have someone kind of going through your personal inbox. If you've had this separate Gmail account, you could just tell the town, here's my login for that Gmail account. You can search for it yourself. And you already know, the only thing in there is stuff related to the planning board, and it's not going to be mixed up with emails from your daughter or your son or family members. So that's one way to deal with having just a separate public business email account.
But we would still have to give permission for that.
You would have to give permission for it, yes.
But so that the town could provide us with londonderrynewhampshire.org.
That would be better.
They own those.
Well, the reason why that's better is all the emails are now in a server under the town's control.
That's what I'm saying, so they wouldn't have to ask permission.
No, they could just go search it anytime they wanted to, and what they would do is they would tell you, we're giving you an email account, but understand it's not private. Anything in the email account is on the town server. We have the ability to search and look into what's in the server. And the reason why that's also beneficial is that the right to know law contains an obligation that public records have to be under the control of the public body. If you have public records that are electronic, which are in someone's personal email account, we don't have control over that. And that is technically a violation of the right to know law. Again, I think that discussion and deliberation of official matters should be left to public meetings or a properly held non-public session or at a non-meeting as necessary, as discussed previously. Now let's get a little bit more detail talking about public comment. I've kind of touched on this before. We've gone over it a little bit. We've probably covered a lot of the rules. But again, I want to emphasize there's nothing in the right to know law that says you have to let people speak at a public meeting. But there are occasions where you have to have a public hearing where the public has a right to speak. But a pure meeting under the right to know law, remember those two columns, we had public meetings and then public hearings. If it's just a simple public meeting under the right to know law, the public does not have the right to public comment. But you may want to have a public comment period. So you have to have rules of the road. And that's where the ability to regulate speech intersects with your duties under the First Amendment. And the way in which governmental agencies deal with the ability to regulate speech reasonably under the First Amendment is to only regulate time, place, and manner. Anytime government tries to regulate the content of speech, you're going to get in trouble. So that's why the Supreme Court, in its rules that govern the First Amendment, tell government, don't regulate the content of speech, but you can regulate the time, manner, and content, time, place, and manner of the presentation of speech. So time, you can tell people at a public comment period, they have 2 minutes, they have 3 minutes. That's the time they have. The place is at the public meeting when they're allowed to come up and they can sign up for presentation at public comment period. And the manner, you can to some degree regulate the manner of speech. So speech which is designed to suggest that the speaker wants to engage in fisticuffs with a member of a public body, those are fighting words. And fighting words are not considered to be protected speech. Obscene speech would also not be considered protected speech. However, realistically, use of a 4-letter word in the course of a public comment would not be per se obscene speech, so you could not cut someone off when they're using obscene speech of that type. In fact, there's a famous case from California where a young man who was very opposed to the draft walked into a courtroom. This is a case entitled Cohen versus California. He walked into a courtroom in 1968 with a shirt on that had the words F-U-C-K, the draft, in big bold letters on his t-shirt. He walked into a courtroom, sat in the back of the courtroom without uttering a word, sat down and proceeded to just be present during a trial. And a court bailiff came over to him and said, take off the shirt. And he said, no. And ultimately he was arrested for disturbing the peace. And the issue was whether or not the wearing of that shirt was in fact disturbing the peace that would allow the bailiff to arrest him and remove him from the courtroom. And the answer by the U.S. Supreme Court Justice Black was no. That is protected speech. We may not like the manner in which he's expressing his opinion, but he's clearly expressing an opinion on a matter of public import. And as a consequence, government cannot regulate the content of speech. So realistically, you're going to have people at public comment use bad words, and that's not going to be enough to cut off their speech. Yes?
But where you say First Amendment, many restrictions are not acceptable, there are restrictions that are acceptable then. If somebody wants to speak to something that's not on the agenda,
Yes.
that is unacceptable.
Yes, however, under the First Amendment, you probably have to have a safety valve. So your rules probably have to say, presumptively, public comment for things on the agenda. But then you also probably have to put an asterisk next to that and have it say, if you want to speak on something not on the agenda, you have to ask our permission, and we will seriously consider your request. And you probably have to consider their request. So if they do want to talk about the weather in Mozambique, and it's not related to anything on your agenda, you might need to give them that flexibility. I'm just being realistic here, because if you just shut out any alternative communication at your public meetings and only things on the agenda, you might run into a problem under the First Amendment. One other thing I would say, however, is repetitive speech is disruptive. So if the same person came to public comment and said the same thing time and time again, you probably could say, sir, this is the third time you've spoken at our public comment period, and you're speaking on the exact same thing, saying the exact argument that you've said the last 3 times, or the last 2 times. This is disruptive speech because it's repetitive, and it's impeding the ability of government to get the job done. We've heard you once, we're not required to hear the same thing time and time again. That person could be cut off.
What if you heard the same argument against a specific item by different people? The same-
Probably you're going to have to let all those different people make that same presentation. At some point, however, if you could be able to suggest that the same people are saying the same things and they're all part of the same group, you might be able to say, wait a minute, we've heard that before. You're now becoming repetitive speech, disruptive speech. You might be able to cut that off. Realistically, there are strategies a chair can use. Now, I don't know if you've ever been up to the legislature, but if you have a long line of people who all want to speak, you know, what they do at the legislature, they have these cards where you check in and the card says, I want to speak, or I support the bill, or I oppose the bill. And you can even put that on the card. And then you can check you don't want to speak because you've expressed your opinion on the card. So you've allowed the person to express their point of view, and then you've given them the opportunity to speak, but they don't have to. A chair could say, okay, Mr. So-and-so, I see you're wearing this shirt that says I'm opposed to Northern Pass, and the 5 people behind you all are wearing the same shirt. Is it possible that you could say the same thing for everyone who's about to speak behind you, and we'll be able to then move forward with everyone in the room, because we have 25 people, and the first 5 people appear to be all of the same group, and they all perhaps would have the same presentation, and the chair might be able to use moral suasion to convince one person to speak for 5. So there might be some way to minimize, you know, a prolonged presentation on the same point of view 5 times in a row. Something to think about in terms of how the chair manages the meeting. Some of the things that you cannot have in a public comment rules of procedure is that only positive comments are permitted. You can't do that. You certainly cannot do, we will not allow criticism of public employees. There have been towns that had rules that say public employees could not be criticized. That would not be permissible. You could not have a rule. There was one particular town that had a rule that said there would not be inappropriate criticism of members of the public body. That would not be a permissible form of regulatory conduct with regards to public meetings and the public hearing process. So long as you limit your time, place, and manner, 3 minutes, stay on topic, be related to something on the agenda, you're just going to let them fly for the 3 minutes, and then you'll move on to the rest of the agenda later on. Yes?
So how do you consider somebody that wants to be disruptive and personally attacking one of the members of the board, and distinguish the difference between their rights under the First Amendment and what you just said a few minutes ago?
Personal attacks, if I'm speaking to a public body and I am saying that council member X is corrupt, that's not going to be a basis to tell the person has to stop speaking. So what I'd like to do is show you a video, and then I want to talk to you about the video, but this is a video of an actual public hearing at a town, in the town of Alton. So we just want to bring up, you have to bring up the
Okay, open public input 1, and our rules of public participation is on the back page of the agenda at the table. You enter.
Is it open?
Yes.
I'm going to start my clock here so I don't get shortchanged in my 5 minutes. My name is Jeffrey Clay, and I'm from Alton. And every time I show up here, it is with my most fervent hope that I'm going to find that you folks have resigned. But you still continue to show an unwillingness to step up to the plate, take responsibility for your poor actions as selectmen, and resign. I'm asking you to do that now. It just takes 2 words. Stand up admit I take responsibility for all my poor decisions, for my poor actions, for the continued violation of the citizens' rights here in Alton.
Point of
And
order. Is this a character assassination?
and resign. All you have to do is stand up and say, I resign. That would be a good thing for you to do, to say,
Have a point of
I
order.
resign. You just stand up and say, I resign.
We have a point of order at this time. Does
It's my understanding,
have a
this-
second on the point
it's
of
my
order?
understanding this board does not pertain to Robert's
Second.
rules of order.
Okay, and you
You do not continue.
you feel that he's violating the
Do you or do you not go with Robert's rules of order?
libelous,
You won't answer the question,
Statements.
right?
Yes.
is the board feel that the
You really need to
comments
stand up and
currently done
resign.
is a libelous
The public needs to hear
Inflammatory
you do
statements.
that.
discussion?
I gotta stop my time here.
All in favor of closing down public input at this time because of the defamatory statements made by Mr. Clay? Say aye. Aye. Opposed? Thank you. Public input's closed.
Integrity is the quality of being honest and having strong moral principles, moral uprightness.
You are
It is
done, Mr.
generally
Clay.
a personal choice to uphold oneself
Clay,
to
I'm
consistently
asking
moral
you
and
second
ethical
time.
standards.
Clay,
Integrity also
I'm telling
demands
you the third
knowledge
time.
and compliance with both the letter and the
Chief, would you
spirit
please ask him?
of the written and unwritten rules. To this end, this board is
I'm telling him
morally
that he's-
corrupt. It is bankrupt.
He can sit in the audience.
It
but
is
he's done
without
with public
integrity. We citizens pay the
Public
price.
input is closed.
You want to take your hands off me, please?
You've been
Take your
asked
hands
to
off me,
leave.
please.
You've been asked to leave.
Take your hands off me, please.
You've been asked to
Take
leave.
your hands off
Are
me,
you going to
please.
stand up and leave?
We citizens,
do not, I'm
we
gonna place you under arrest
the
for
citizens
disobeying
pay the
direct orders.
price and legal fees
Come on.
for your representation.
Come on.
Two little words, resign.
Clay, come on.
Am I under arrest?
Come on, you're going to be if you don't listen to me.
Stand up and resign now. Alton deserves better. Audacity is defined as boldness and daring, especially with confident, arrogant disregard for laws and rules and policies.
Clay, you've been warned the third time now.
Continued violations cannot be tolerated by the public.
Public input has been
Stand up, take responsibility for your willful violations of the rights of the community. Resign. Do it now. Two little words. Stand up and resign. How can you possibly hold...
Okay, now you are under arrest. Come on. Come on. Come on.
Do we have any other public?
He has some,
Oh,
he was trying to get backup,
he's going.
Yeah, he was.
but
he was Okay, trying to yep. get
backup.
Any other public input? Yep. Could you just move that over Bob for us? That'd be fine. Thank you.
I would just like the record to show that one citizen is very happy with the select people, and you don't have to stand up and resign on my account. I like what you're doing. I've just been running down the agenda, and I see new business.
Okay, so what I would tell you about this particular, if we could just bring up the PowerPoint again, and then just go to the current slide. Yeah, there we go. So this was Alton versus Clay versus Town of Alton. And now, why did the public comment period get stopped? Well, in fact, Alton had a set of public meeting participation rules that said defamatory and libelous statements are impermissible at a public comment period. And it turns out that's in direct violation of the regulation of content of speech. One of the things that is reality if you're a public servant, you're going to have libelous statements of this type by people like Jeffrey Clay made at you at a public meeting. And you're not going to be able to cut them off as he was. Now, he was arrested, and he eventually brought suit in federal court, and in fact, Alton lost because his rights for free speech were tarnished, were stepped upon, were violated by his arrest. Notice also, one of the things that happened in this, they voted to close the public comment period, And then they let someone else speak, and they let him speak because they were speaking favorably about the select board. And that didn't go well when eventually that was played to a federal court judge. So I guess I would say, and I understand the gentleman's concern about people saying libelous and slanderous things to you. Really, if you have a set of public comment meeting rules that limit those comments to 2 or 3 minutes, you're probably going to have to suffer through those kind of things. You can tell them to stop repetitive speech, and some of his speech may have been repetitive, but probably not enough to warrant cutting him off.
So could you do something creative maybe by somehow continuing the meeting for another time and have the public body leave at that point so that he would be still continuing his speech, but people wouldn't.
Yeah, I don't think that's going to work.
I'm just wondering, because we haven't stopped the speech, but we've actually continued
Yes,
the meeting.
well, yes, you have stopped the speech, because obviously you created a forum, and there's a whole analysis that would go into, you created a public forum, the forum is the public comment period and public body, and all of a sudden now you're taking the public forum and you're removing it. So I think there would be a problem in denying the right to speak to that particular person, because you didn't want to hear that person's speech. You didn't have a legitimate time, place, and manner reason to stop him from speaking. You stopped him from speaking because you didn't want to hear what he had to say. And that's problematic under public meeting rule procedures under the First Amendment. Yes?
He appeared aware that he had a 5-minute limit, so if
Yes.
you let him rant for 5 minutes, then what's the recourse system?
Nothing. 5 minutes, he's done. You say, okay, if he goes over his 5 minutes, then you can arrest him. So what I would just refer to is there was a case that was, when you're dealing with difficult people, this is Bear versus Leach. This is actually a case in the United States District Court for the District of New Hampshire, where one of the things that take place was a public comment period. Now, one of the things you can do at public comment period is not necessarily a question and answer session. So if I come up in public comment period and the rules say public comment is for your public comment, but it's not for you to engage in a debate with the council or with the board, it's your opportunity to comment. If you have a question, we'll try to get you an answer, but we're not required to answer it. So this was a situation where I think it was there was a school board also in the Lakes region where they had a public comment period, and this guy came up and he spoke in public comment, and then he started engaging in questions. And the board said, look, sir, this is not a question and answer session. You have something to say to us what you want to say. Your time is up. When his time was up, he went back to the audience, but then he kept speaking. And he kept saying, wait a minute, why didn't you answer my question? And I want to be heard. And the chair said, look, sir, you've had your 5 minutes. Now you're interrupting someone else. Please be quiet. And he had to be admonished 3 times. And eventually, a police officer was standing nearby, and the chair said, look, we've told this gentleman he's had his chance to speak. He's now interrupting someone else. He's continuing to pose questions which we're not required to answer. And eventually, he said to the officer, why don't you just arrest me? And the officer said, okay. And he arrested him. And under that circumstance, his behavior went so far, it was disturbing the peace and impeding the business of government. And when someone who is using free speech to do that, they can be arrested and removed. The same thing happened in the State versus Dominic case, it's a famous case in New Hampshire. It was a select board of 3, and there was no one new selectman, which, look, I've seen it happen many times. The new select board member or council member, they're a lone wolf. They think they know better than anyone else, and they're going to reform town in one fell swoop because their thoughts and ideas are better than anyone else's. This person was a new member of the select board. The select board had rules of procedure, that each member would speak as they were recognized by the chair, and this one select board member was recognized. He was allowed to speak. But then he kept speaking when he was no longer had the floor. And he was told, look, don't interrupt. Someone else is speaking. Please be quiet. He kept interrupting. He interrupted again. And finally, the chair said, look, we have procedures here. When I recognize you, which I've done more than once, or I'm recognizing someone in the audience, please be quiet. Otherwise, you're impeding the business of government. Eventually, he kept speaking, and the chair of the select board had to have that selectman removed, and he was arrested. He then sued the town, saying his First Amendment rights were violated, and the Supreme Court said, no, you were impeding the business of government. You were misusing your free speech to impede the operation of government. So, yes, you can step in, but not in this situation with Jeffrey Clay. If he had just stuck to his 5 minutes and he just ranted about their inappropriate conduct as councilman, in this case it was selectman, you would have just had an earful, but then you'd be done with it. Unfortunately, what ended up happening is they had to, and this is the one thing towns don't want to pay, you have to pay the attorney's fees for the ACLU to the tune of about $50,000, which is a lot of money you got to spend to defend a situation where you can cut it off if you have effective public meeting rules. Time, place, and manner. 3 minutes, no repetitive speech. Try to keep it to the items on the agenda, but people are going to rant. And you're going to have to expect that to occur. Yes.
Can you give an example of when you said regulate only time, place, and manner? Can you give an example of how you could regulate manner legally?
Manner?
Yes. Is it respectful manner, or are you talking about
No,
procedural manner?
you know, it really isn't respectful manner. So time, place, and manner in that particular instance, you cannot use speech. Manner really goes to repetitive speech. So you could outlaw repetitive speech. You could outlaw fighting words. It'd be very hard to outlaw just obscene words in and of themselves. So generally, you know, under the First Amendment, there are certain forms of speech that are not protected. So the classic rubric is you can't, and this was from the World War II case, you can't print in a newspaper the sailing time of troop ships that are sailing from America to Europe, because that would alert the Germans they could torpedo the troop ships. You can't, fighting words are not protected speech. You can't yell fire in a crowded theater. That's not protected speech. If it falls into one of those, obscene speech is not protected speech, but the reality is, as long as it has some, it has to appeal to the prurient interest and has no socially redeeming value. So what it used to be is the porn stars would be reading Shakespeare plays while they were carrying on in their various activities in the porn industry, and that was seen to have some redeeming social value. So it's very difficult to regulate obscene speech. But fighting words, yes. If the speaker comes up from the podium and is saying, okay, Mr. Chair, let's take it outside and we'll fight about this, that's not protected speech. But, you know, you can't regulate speech by saying you can only use speech which is friendly, or you can't use libelous or defamatory words. And that's where Alton got in trouble. Their rules of procedure said defamatory or inflammatory words were not permitted, and that was not permissible. Yes?
So we wouldn't be able to shut somebody down for using, say, obscene language, but...
A few obscene words, no.
But would it be appropriate to just ask for their, to concur that it may be not appropriate to use obscene language?
Absolutely. As a chair, you could say, sir, I want to admonish you that we have many people who don't appreciate that kind of language. I don't appreciate it. Please keep your language such that you're not using obscene words. Admonishment makes sense, but telling the person you're done because you just used the word F-U-C-K, that's probably not the best way to proceed. So again, the best approach is limit it to 2 or 3 minutes, limit it to items on the agenda, have a safety valve so people can speak on non-items on the agenda under reasonable circumstances, and just let it fly. And that's probably the best way to achieve compliance with the First Amendment. So I have really already talked about public meeting minutes at some length, so I won't go over that again. And I've already talked about, you know, roll call votes and manner of doing roll call votes. So I've really covered pretty much all the topics. So we've done the 2 hours. I'd be happy to answer any questions, any additional questions you might have. Yes?
Just out of curiosity, the FCC has a number of rules about obscene language going on
Yes.
the airways, and you're televising these on CCTV. Is that any kind of announcement?
No. Okay, so the FCC, we're talking about over-the-air broadcasting. Cable, if you know, if you've ever gotten HBO, cable is not regulated in terms of the FCC, in terms of obscenity. When we're talking about FCC regulation, that's over-the-air broadcasting. That's radio, and you know, maybe George Carlin had the famous 7 dirty words. And so the FCC does have the authority to regulate that kind of content, but it has a particular meaning. I won't get into the First Amendment details, but it has to do with the fact that there are children that might be able to hear it, and there's kind of rules about that. But that's just because it's over-the-air broadcasting. cable broadcasting, stuff that comes over your cable system, such as local cable access, that's regulated totally differently.
So if the town had a radio station and were broadcasting the town meeting over the radio station, that would be...
Well, then you might run it, you'd have to be licensed by the FCC, and then you might have licensure limitations in terms of how you have to comply with the FCC rules. So you probably, when you have those kind of standards, you have to have a delay so that you can have a gag, you can bleep things out. The TV stations, radio stations all have that. But I don't think any town really wants to have a live radio broadcast. It's usually your PEG channel, your public education and government channel, that's what those things are called. The PEG channel, which are available to you through the franchise arrangement you have with Comcast, assuming Comcast is your cable user in your particular municipality. Yes?
I just have a question, but in general, when you're having a town meeting, a lot of times I've been at meetings where I'm sitting back here, and they're conducting the business, and we have people in the audience who are making loud statements and things like that. Can the chair remove that person, or can they limit the whatever they're saying? Because in many cases, you can't hear what's going on.
Right.
Because the person's being disrupted.
Well, let me give you a suggested strategy, which I had recommended to me by a moderator. One of the things that's true, and I've seen this, I used to conduct processes where I was trying to manage large public gatherings, and there's things you learn about how to manage large public gatherings, and people are being disrupted, either in the back of the room, as the case may be, and preventing the meeting from going forward. One very effective strategy is, if you have someone who's popping off in the back of the room, you say, we're going to take a break. And the chair marches to that person, preferably with the police officer by his side, and say, sir, this is not appropriate. Keep it up. You're going to have to take steps to have you removed. You want to speak and come up with public comment period. You're sitting in the audience, we expect you to be quiet. And you speak them face to face. Because one of the things that person wants is an audience. So if you're up with the public, speaking to the person, that's exactly what they want. They can pop off, and they've got the whole audience. You've got them face to face, and you're admonishing them, stop this behavior, we may have to remove you. A lot of times it's a very effective way to stop that right in terms of how it's going on. The person will stop much more quickly rather than being admonished, because they feel like it's a teacher talking to them in a room full of students, and that's just the kind of audience they want. So I think that's one approach. But if someone continues to pop off like that, you can say, hey, you continue to interrupt the meeting, we're going to have you removed because you're disturbing the peace and you're disturbing the business of government getting the job done. So that's just one thing to consider, how to deal with that. Any other questions? Yes?
So when you're talking about time limits, you were saying also that some boards have different requirements. So a land use board, planning board, zoning board could put time limits on, typically, at least in our format, is, the presenter speaks.
Yes.
People get up and are for or against whatever.
Right.
You can put time limits on that?
I think it certainly makes sense. Here's my concern, because I've seen this. Applicant comes in with the engineer for this, you got the drain engineer, you got the wetland scientist, they've got a battery of people, and one after another, and pretty soon, the initial presentation has taken up 2 hours. And the abutters are sitting in the room, they're fuming. Like, when do we get a chance to speak? So I think it makes sense to, in those kind of circumstances, say, look, we're going to let you make a presentation, but, this is not an application by filibuster. We hear from you, and then we only reserve 5 minutes for the abutters. So a reasonable management of time to respect the interest of all parties certainly makes sense, so you don't have the applicant suck up all the time and everyone else has to wait till 1 o'clock in the morning.
But do you have to notify the applicant in the group that the limit's 4 minutes, and if you so desire, you'll
Whatever, yes, you can certainly do that. The chair could do that at the beginning of the meeting, is to announce, look, we have a contentious application. We have to give it a chance for the applicant to be heard. He's got a few representatives who are in his engineering, list of parties who want to, they're experts who want to present information, and you're going to manage that time in a way that respects their interests, but also the interests of the abutters and other interested parties, to use the time effectively. And you're going to have the attorney who's going to bitch, moan, and complain about, I've got all these people, they're costing me all this money, they all ought to be heard. And But you as the chair also has a duty to help the abutters participate and not have an applicant by filibuster.
So my question is, do we have to in our rules, say we have a 4-minute limit that may be enforced?
Well, I think you could have a standard operating procedure that might be modified given the circumstances. Or you might say, we have a set procedure where the initial presentation by the applicant can take no more than 30 minutes. If you need more time, you gotta let us know beforehand. And then, when you start that public hearing on the contentious application, you let the other one in the room, the applicant's gonna have 30 minutes to make their initial presentation. We will try to give as much or similar time to those in opposition to make a similar presentation. So there's fairness communicated to the parties who are there, opposed and supporting, so they know they're all gonna have a chance to be heard. So you could put that in your rules, or you may have to modify it given what you have in front of you. I mean, you may think there's going to be a contentious application, the room's going to be full, and it may turn out not. Or you may turn out to have a room full of people, and you might have to say, okay, we're at agenda item number 3. It's 8 o'clock. We've said we're going to start the hearing now. Let's get going. But we're going to have to manage our time a little bit differently because we have a full room. The other thing, which is always very good to have as a rule, and this is something our planning board did, and I think any board can do that, is say we will not take up a new item after 10:30. Because it could be you start that new item at 10:30 and it goes for 2 hours. You're 12:30 in the morning. And I've had hearings go to 1 o'clock in the morning, and I'm going to tell you, there's nothing worse than having a meeting at 1:30 in the morning, and it's Thursday, and I got to go back to work Friday morning. It's a killer.
You do notice that it's at the board's discretion.
But I think cutting things off and say, look, we're going to stop at 10:30, or we're not going to take up a new item after 10:30. So those are some of the things you can think about to help manage your time. Again, because you don't know what's going to happen until you show up, and all of a sudden the room is full. Okay, we're going to have to be careful with how we manage the time on this one.
It kind of gets, instead of public comment, like maybe that Alton board meeting is, where obviously it's clear they have 5 minutes. Because planning boards and zoning boards are getting presentations.
Right.
So how do you notify that that 5 minutes is up? I know it can have something.
You might just have to say the chair is going to have to keep track of that time, and that person the time is up.
So it's okay for us to say that's
Yes.
the limit at our discretion?
Yes, I think you can do that, as long as it's fair to all concerned. I think that's the key thing. But to the extent you're going to have presentations in terms of the format for presentations, whether it's a ZBA variance application or a subdivision site plan, you probably should have some standard format for how it's done in your rules. Applicant will, in a standard presentation, get 15 minutes, extended at the will of the chair, as the case may be, and put that in your rules of procedure, and then modify them as necessary, given the circumstances. I had another question. Yes?
A procedure question. If you have several issues in the evening, could you have a list for people wanting to speak, sign a list, saying, I want to speak on this issue with
Yes.
other people? And then you take that and you say, okay, I go down there as a way of kind of
Absolutely.
keeping things under control.
And the other thing you can do is you can say, I think I've been very effective. Let's say people are now coming to speak on the ZBA application, and it's been a presentation by the applicant, and the abutters have spoken, and you see a long line of people who are standing. One of the chair could say, look, before I hear you all, which you have a right to be heard, can I just have a show of hands of those who support the application? And no hands go up, that's fine. And then I can see the hands of those who are opposed to the application. Okay, are those who are here, is there one of you who oppose it who you think would best express your points of view? Oh, okay, you come speak, all right? And then that person speak, and then the next person comes up and say, ma'am, that man, did you agree with what he had to say? Yes. Do you have anything to add or anything new in addition? No, I think he said it very well. Okay, so you support his point of view. Great, thank you. And you can do that with all the rest of the people so that, you are cycling through. You're not telling them they can't be heard. You can say, oh, if you want something new to add, but maybe that person has already covered the topics. Or the person comes up and says, well, there's something else I want to add. Great, let's hear your different point of view, even though you're also opposed. And that's the way you can manage getting through it all, you have a large number of opponents or even supporters, as the case may be. Another strategy. Again, the one that I liked, at the legislature, they have these orange cards, and you fill them out when you come in, and the orange card says, we're going to have a testimony in HB 26, and you can check support or opposed, and the card is put in, and you can also check, do you want to be heard, and your name is on the card. And a lot of people just check, I oppose, and they don't ask to be heard. But the chair will cycle through them. Oh, I've got 15 cards from these people they are supporting, and 15 cards from these people they are opposed, and I've got these people who want to be heard. And then that can go in the public record. So you've actually had a chance for them to be heard in writing, but you didn't have to have them present testimony. Another strategy to get through a long public hearing with a lot of people who want to speak. Yes?
Is there a requirement, absent the 91A request, to ever release non-public minutes?
So you've held a non-public session. So, and I probably didn't spend a lot of time with this, but there's every non-public session starts with a public meeting. And you're at a public meeting, and then you decide, we have a need to discuss a legal opinion received in writing from town councils. You hold a non-public session. And then when you vote to come out of non-public session, what the public body then has to do is to vote. Would revealing the minutes of the just completed non-public session undo the purposes of the non-public session, in this instance, to reveal the confidential communication? So long as you vote, yeah, it would reveal that confidential communications, and we're going to vote to seal the minutes, because we discussed in the minutes what took place, what the town council had to say to us. As long as it's true that your disclosing of that information would undo the very reason for going to non-public session, you can keep those minutes non-public. So there's no reason to make them public unless you no longer have a reason to say that the circumstances no longer apply. Or actually, as the statute says, you seal the non-public meeting minutes when, because I always have to read the statute myself. Where if you would release the minutes, it would render the proposed action ineffective. So long as the proposed action would become ineffective, you can keep the minutes non-public. So as long as it's the opinion of the public body that releasing the minutes would undo the action we're making that ineffective action, you don't have to release them. You never have to release them, as long as that's true.
So, in your example, 5 years later, the matter went before a court and was resolved, and so at that point, it would seem that it doesn't pass the test.
Right, and I would agree. And then at that point, the board should recognize that fact and release those minutes. I would agree.
So, I guess the question is, do they have to? In other words, if there's no 91A request, nobody seems to care, but clearly this is, the test is no longer valid. Is there an obligation for a board to go back and review on an annual basis, say, all of their non-public minutes to determine if any of them should now be released?
What it says is, in the event such circumstances that it would no longer be the case that would render the proposed action ineffective, in the event such circumstances no longer apply, then the minutes should be released. So what it really does, the statute says you're allowed to complete the minutes non-public if to release them would make the proposed action ineffective. But once that is no longer true, the legal case went to final decision. There's no need to keep the attorney-client communication confidential. You're supposed to unseal them and make them available for the public. The statute doesn't say you have to meet once a year and decide which minutes in the prior year that were concealed non-public meeting minutes they have to be unsealed. There isn't something in the statute like that. But it is a good practice, and it's one that we've recommended to boards, that once a year it should look back and all at their non-public sessions and the minutes of those non-public sessions and decide which ones no longer need to be sealed. And to unseal them. And especially the ones that the most common is when you voted to hire someone. So hiring is a typical session in non-public where you don't want to reveal the decision you've made until you've cut a deal with the person you're going to hire. Because typically you've got 5 candidates, A, B, C, and D. And you're going to decide which of these you're going to hire. And at the non-public session, you've decided to hire B. But you don't want to let A, C, D, or E know that you're hiring B until your town administrator has contacted B, made them the offer, they've accepted the offer, and they've signed the contract. And then you notify all the other parties, sorry, you didn't get the job. But if you do it beforehand, B may not agree to take the job because you're not offering enough money, and you're going to have to go to A or C, and you want to hold those in reserve until you've made the final decision. But once you've made the final decision and the person's working for you, there's no reason to keep the minutes non-public anymore, unless, I suppose, there could be some injury to reputation. So one of the things that might be true is the applicant E told you, oh, by the way, I haven't told my employer I've applied for this job. And they might not want to know their current employer is going to be notified that they've applied for a job for someone else. And so as a consequence, they want to keep that information secure from disclosure to the public or their current employer. So it really depends on the circumstances, but certainly the fact of hiring in Mr. B, yeah, at that point you would make known to the public, yeah, we offered the job to Mr. B and he eventually accepted the job. And at that point, you would disclose that information. So once a year, it kind of makes sense. But what I have told a number of city councils, assign one city council member once a year the duty, maybe you give it to the newbie, to sit down with all the non-public meeting minutes and go through them and decide which ones could be legitimately unsealed, and then have that person come back to the council with a consent item. I would recommend we unseal these minutes. And as long as there's no objection, the board would then vote to unseal them and make them available to the public. And that is an affirmative duty, even though there's no one knocking on your door asking for them. Because the statute contemplates you're going to do that once the reason for originally sealing them no longer apply. That's how the statute is worded. So we're heading towards 9:30. So I don't see any more questions. So I would thank you very much for your attendance and appreciate your having me here. Thank you. And I do have an extra packet here in case you need one more.